Good day, sir. I'm Alavaren Alavaren from Section B, and this is my final oral video examination. Number 1. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Scope. The rules of evidence shall be the same in all courts and all trials and hearings, except as otherwise provided by law or these rules. Number 2. Object as evidence are those addressed to the sense of the court when an object is relevant to the fact in issue. It may be exhibited to examined or viewed by the court. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, and sounds. Testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge. Number 3. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. Number 4. Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Number 5. According to Section 37, Dying Declaration, the declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry. Number 6. According to Section 44, part of the res gestae, statements made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given evidence as part of the res gestae. Number 7. According to revised rules in evidence 132, Section 4, Order in the examination of individual witnesses, the order in which the individual witness may be examined is as follows. First, direct examination by the proponent. Second, cross-examination by the opponent. Third, redirect examination by the proponent. And third and fourth is the cross-examination by the opponent. Number 8, the Judicial Affidavit Rule or JAR took effect on January 1, 2013. A normal court proceeding will take around 3 to 5 or even more years to be fully decided. By requiring the submission of written affidavits of witnesses through the JAR, the time for concluding a court proceeding will be shortened. Number 9. What are the two exceptions? The first is in quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, reckless imprudence and simple imprudence or negligence. Second, those allowed by law to be compromised, their usual examples are found in the Revised Penal Code, particularly Article 266D of the Revised Penal Code. Number 10. Relevance. Relevance evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. Competence. In addition to relevance, admissible evidence must also be competent under Rule 128, Section 3. Evidence is competent if it is not excluded by the law or these rules. If a piece of evidence is disqualified by the law or the rules of court, then it is not competent and be inadmissible. Number 10. According to Section 10, leading and misleading questions, a question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except on cross-examinations on preliminary matters when there is difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, or a deaf mute, of an unwilling or hostile witness, and lastly, of a witness who is an adverse party or an officer, director, or managing agent of a public-private corporation, or of a partnership or association which is an adverse party. Number 12. A misleading question is one which assumes as true a fact not yet testified to by the witness or contrary to that which he or she has previously stated. It is not allowed. Number 13. According to Section 4, circumstantial evidence when sufficient, circumstantial evidence is sufficient for conviction if, first, there is more than one circumstance, second, the facts from which the inferences are derived are proven, and last, is the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Number 14. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact and in issue to establish a prima facie case. Number 15. Standard of proof necessary in civil cases. Preponderance of evidence, how determined. In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. Criminal cases, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Administrative cases are briefly defined it. Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable end might accept as adequate to justify a conclusion. Substantial evidence is the least quantum of proof required by the rules. It is applicable in administrative actions which, unlike judicial actions, do not include conducting full-blown trials and are meant to be concluded with greater speed. Number 16. Public documents. First, the written official acts or records of the sovereign authority, official bodies, and tribunals are public officers, whether of the Philippines or of a foreign country. Second, documentary acknowledged before a notary public except last wills and testaments. Third, documents that are considered public documents under treaties and conventions which are enforced between the Philippines and the country of source. And last, public records kept in the Philippines or private documents required by the law to be entered therein. All other writings are private. Number 17. Proof of private documents. Due to execution and authenticity must be proved by any of the following means. First, by anyone who saved the document executed or written. Second, by evidence of the genuineness of the signature or handwriting of the maker. And last, by other evidence showing its due to execution and authenticity. Number 18. The original document rule states that when presenting a document as evidence, only the original is admissible. And the exceptions. According to Section 3, original document must be produced exceptions. First, when the original has been lost or destroyed or cannot be produced in court without bad faith or on the part of the officer. Second, when the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice. Third, when the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. And last, when the original is a public record in the custody of a public officer or is recorded in a public office. Number 19. According to Section 20, witnesses, their qualification. All persons who can perceive and perceiving can make their own perception to others may be witnesses. Number 20. According to Section 3, extrajudicial confession, not sufficient ground for conviction unless corroborated by evidence or corpus delicti. That's all, sir. Thank you.